we know, is Rod Rosenstein doing a good job supervising this investigation? And what do we think of the job that Bob Mueller is doing? We have two outstanding panelists with us here today to address some of these questions. We will first hear from Ken Starr, who has had a very distinguished legal career. He clerked for Chief Justice Warren Burger on the Supreme Court and served in a number of significant positions, including judge on the D.C. Circuit Court of Appeals, Solicitor General of the United States, independent counsel in the Whitewater investigation, Dean of Pepperdine Law School, and President and Chancellor of Baylor University. He is also the author of two books, including The Individuals Who Were Connected with the Bombing of the U.S. Embassies in Kenya and Tanzania. He is the director of the Center for Law and Counterterrorism at the Foundation for Defense and Democracies, and he is a regular contributor to Fox News and National Review. With that, Judge Starr, the floor is yours.
Well, thank you. I may remain seated if that's all right, and provide a series of reflections really just to get the conversation going or to continue the conversation. There's one dimension, since impeachment is in the air with the midterms ahead, that I thought I would begin with. So I'm going to begin sort of at the end and then hopefully scroll back to the beginning. In stark contrast to the independent counsel statute, the regulations under which Rod Rosenstein appointed Bob Mueller are silent with respect to the issue of impeachment. The independent counsel law was acrid with impeachment. Those are the words that Antonin Scalia used in his dissent in Morrison versus Olson. When one thinks of the context out of which the law emerged, namely Watergate, and we think back to that time, for some of you entirely history, but for those of us who lived through that time, in 1978, when the Ethics in Government Act was passed, the idea was so fresh that the impeachment of the president was a moral imperative, and he resigned, sparing the country the articles themselves, and then the trial that would likely have resulted in his removal, though obviously speculation. And so when Congress turned to codifying the concept of a special prosecutor, as then called, then eventually more mildly called the independent counsel, now we have the even milder special counsel. What Congress really had in mind was, we want this law officer to be out there going about and sending us information so we can impeach someone. And it therefore is little surprise that Bernie Nussbaum, the first counsel to President Clinton, when the issue became, should President Clinton reauthorize or sign this reauthorization of the statute into law, he said, and I described this scene in the book, Mr. President, this is a dagger aimed at the heart of the presidency. So it was as if Bernie Nussbaum, a very able, shrewd New York litigator, had read the Scalia dissent and took it to heart. The issue that is so intriguing to so many of us in terms of the mechanism for assuring honest government and reminding ourselves of what was stated by Mr. Madison in the Federalist Papers, that if men were angels, would make that gender neutral now. If people were angels, government would not be necessary. But there was the whiskey ring. There was, in fact, wrongdoing. There was Teapot Dome. I think it does behoove us to say that in Teapot Dome, the Senate found what may be the immaculate approach to an investigation of either the president or those close around him or her, and that is the appointment of two special prosecutors or special counsels confirmed by the United States Senate, one from each party. That seemed to work out pretty darn well in Teapot Dome, but the Teapot Dome mechanism has not been tried since. I wonder why that is so. The special counsel mechanism was, I think, as untidy as it was all right. It was working fine. But then Archibald Cox being fired so inflamed the country that not only did we have the appointment then of Leon Jaworski to be, but Congress said, we have to do something. Reform, reform. Which reminds me of the story of the backbencher in the House of Commons who stood up and yelled at the top of his aging lungs, reform? Don't speak to us of reform. Things are bad enough as they are. And so it was, I think, with the independent counsel statute. What was wrong? The mechanism of political pressure and moral outrage ended up having this corrective function so that now here we are with special counsel regulations that have essentially been in place for 20 plus years, since 1999, or going on 20 years, I guess I should say. And these regulations seem to have stood the test of time. We shall see. That brings me then to Bob Mueller and the expansion of jurisdiction. The regulations are very clear. When you parse the words of the regulations under which Bob Mueller was appointed, you cannot have a rogue prosecutor out just deciding, I think I would like to look into this, and I would like to look into that, without a check. It is very clear under the regulations that Bob Mueller must have the specific approval of Rod Rosenstein as the acting attorney general in order to open some new avenue of investigation, of inquiry. What was not understood, as I try to describe in the book, this just kind of eluded the American people, and so perhaps we can, Keith, take part of the blame for not engaging in vigorous enough education, but that wasn't our job. It was really Congress's job and the Justice Department's job to engage in the public education function, not ours. But in any event, it was absolutely clear under the independent counsel statute that for an expansion of investigative authority, the independent counsel had to go to the Attorney General of the United States. There was that check in the statute itself. And then the Attorney General would make the assessment, and hers was, I believe, non-reviewable. We can talk about that. In other words, there would be no check on the Attorney General's authority to say, no, well, I'm not going to expand your investigation. If she agreed, then she, next checkpoint, would go to the special division, the three-judge panel of the U.S. Court of Appeals for the District of Columbia Circuit. And in theory, they could say no. I think it would raise separation of powers questions if they did, but at least the nation had, if nothing else, the symbolic approbation of three judges, and one of whom was appointed during my tenure by a president of the other party. So there were these sort of checks and balances in place before the Lewinsky investigation began. So as I describe in the book, and again, this is something, John, that I felt was important, at least as part of the historical record, given the lack of understanding, misunderstanding, and just the political rhetoric that was flying around at the time, that there was, in fact, a review by Janet Reno herself of the evidence. She had terrific lawyers, career prosecutors around her, and in fairly short order, she made the determination that whether Monica Lewinsky and others had committed perjury, other offenses against the rule of law, had to be investigated, and the logical shop, alas, some people draw the short straw, the logical shop to do that investigation was your humble correspondent here today. Now, one of the things I do in the book, and this relationship, and I think it's why the independent counsel statute simply cannot work, quite apart from the constitutional questions raised so brilliantly by Nino Scalia in his dissent in Morrison versus Olson, is that inevitably there's going to be a division turning into a gulf between the independent counsel and the Department of Justice and the Attorney General personally. As I recount in sorrow, I hope it's not anger, Janet Reno transformed herself from a supporter of the investigation to an active and deliberate opponent of the investigation, because the stakes were just very high. I talked to her only once about the relationship during the Lewinsky phase. And that's when she said, I'm now going to investigate you. And as I describe in the book, Attorney General Reno, I think that intrudes into the independence of the independent counsel. I don't care. I'm paraphrasing. I'm going to avoid. So that gulf that suddenly developed, that vast gulf, is something that the special counsel provisions simply avoid entirely. Because you see, and it's symbolized, Andy, I think, as I pass the baton, by the fact that indictments returned by the Mueller investigation are typically announced not by Bob Mueller, but by Rod Rosenstein. Because you see, Bob Mueller is an officer of the Justice Department accountable to the Attorney General. And in that structural reform, a good reform, I think we are structurally consistent with our separation of powers in a much better place. It does carry with it certain things such as the president will not be indicted unless the Department of Justice changes its fairly long-held and well-articulated constitutional view. I don't agree with that as a matter of constitutional law. I respect it. It's a perfectly reasonable position. And since I have the floor until there's a yellow light on. I use this hypothetical in the wake of Clinton versus Jones, which I think is another example of President Clinton's contempt for the rule of law. So he took the position, as his people who lived through it will recall very vividly, that the president should not be subjected to civil process throughout his tenure as the President of the United States. And the Supreme Court of the United States rejected that proposition 9-0, with a very thoughtful concurring opinion by Stephen Breyer. And the thoughtful opinion, which I commend to everyone in light of the currency of these issues, and the respect for the presidency, which we all very much agreed with. Respect for the presidency means that his schedule must be protected and so forth. The district judge overseeing a grand jury investigation or what have you must be very respectful of the president's needs, North Korea, whatever it might be, a replacement for Nikki Haley, whatever the object. You need to be very respectful, but that doesn't mean that the president gets a pass for however many years, as many as 7 to 8 years. Now, in light of that, unless the Supreme Court were to say, we were wrong in Clinton versus Jones, I don't expect that. Imagine the following hypothetical. This is on the indictment of the president. The president, and we're going to make it a hypothetical president, but presidents tend to play golf, right? They just do. So Eisenhower, I guess, started it. No, William Howard Taft started. So anyway, so imagine the following situation, that we're out on the golf course and the president, in a fit of anger, clubs his caddy. Just, you've been laughing at me, I shanked the ball and so forth, so here, take that. The caddy comes to his senses and wanders over to the emergency room, says, yeah, concussion and so forth. He said, okay, I'm calling a lawyer. I'm going to sue this guy. Well, he's the President of the United States. I can do that under Clinton versus Jones. Okay, so the courts of whatever, we'll say Kansas. Let's make this a post hoc Eisenhower event. It's hard to imagine, but just stay with me. Then the caddy says, well, this is going to take a long time. I need to bring Ike to justice. I'm going to go over to the district attorney's office. That was a brutal assault. I survived it by very good. And then is told, well, you can sue him civilly, but the district attorney has no authority to indict the president for this kind of battery. I don't think so. But that's the position of the Justice Department, so I leave you with that very, I hope, insightful hypothetical. Do you have this anomaly that the great public interest in the enforcement of the criminal law gets suspended, but the interest of one individual in achieving civil justice does not? Seems odd.
Very odd. Well, it's an honor to be here. It's always an honor to be here at Heritage, but to be on a panel with John and Judge Starr in particular is a thrill and a delight. I do want to pick up where you left the baton, though, because I do think the structure that we now have is as faithful to the Constitution as anything we've had and anything we probably could have. I mean, you could tinker with it here and there. And therein lies the difficulty, which is we're trying to do something through the mechanisms of law that probably was not something that the framers intended in the first place. What the framers thought would happen, I think, is that Congress would rein in presidential excess. And if you think about it, just, we make some sort of casual assumptions about reining in the president now, right? Because of what we have available to us. But until about 1870, there was no Justice Department as we understand it, right? There was no F.B.I. until 1908. It's not conceivable. I would think that what we have in the way of federal law enforcement now, and the whole bureaucratic extent of it, is something that maybe some of the framers would have anticipated it, but I doubt it. And I think, for what it's worth, that what they believed was that they armed the Congress with what was intended to be the arsenal for reining in presidential excess. And what we're now trying to do is bring the presidential excess, have it reined in by the powers of law enforcement under circumstances where in our constitutional system, law enforcement is an executive power. And we really don't want it to be, for a number of good policy reasons, we don't want law enforcement to be carried out outside the executive branch. So I think part of the problem that we have here is always going to be that what we're trying to do probably cuts against the grain of all the assumptions of our system from the start. So how do we go about it? I think we find instantly that the framers were quite right when they thought that it was better to bring a president into line with political means rather than the means of law enforcement, because we instantly see, and we see in particular, I think, with the Mueller investigation, that regardless of what the laws are, it's the politics that governs the situation, right? So, I mean, we have this set of regulations. We have the special counsel who is part of the Justice Department's chain of command. He's basically a federal prosecutor under a separate set of regulations, but nonetheless functioning as a federal prosecutor who has to rely on the Justice Department for what his jurisdiction is. Probably all works right on an organizational chart. But the fact of the matter is, whether a special counsel gets appointed or not is usually a function as much of the politics of the situation as the apparent evidence that there's any criminal violation. And what we have seen happen again and again is that independent counsels end up getting appointed because of the political noise in a situation, not necessarily because of what the quantum of evidence is that there is a crime. In this particular instance, we have a situation where the Deputy Attorney General, in appointing the special counsel, relied on the testimony of the F.B.I. director, then Jim Comey, in I think it was early March, maybe mid-March of 2017. And when Comey, in that statement that he made in his House testimony, announced that they actually had an investigation, the FBI did, of Russian interference in the election. Highly unusual for the FBI to publicly announce that they have an investigation, but also announced that there was a strand of that investigation that involved the possibility that the Trump campaign had coordinated in Russia's interference with the election. I think the problem with that, if you're going to base an investigation on it, is that Director Comey flatly said that what the FBI was conducting was a counterintelligence investigation. The regulations that we have for special counsels do not provide for appointing a special counsel for a counterintelligence investigation. And there's a very good reason for that. In most counterintelligence investigations in the Justice Department, there is no prosecutor. Basically, the prosecutors are there to help the intelligence agents in the Bureau in the event that they need to go to the FISA court to get surveillance warrant. If they are looking to do some kind of investigation that's actually covered by the Foreign Intelligence Surveillance Act, that's the support role that Justice Department prosecutors play. But it's not like in the criminal division, where typically the FBI and the prosecutors will work together with an eye toward building what everybody assumes in the equation is eventually going to be charges and an indictment. A counterintelligence investigation is essentially an information gathering exercise. It's not intended to build a criminal case. And in fact, one of the big controversies that we had during the 1990s was the fact that the Justice Department interposed what was known as the wall between the law enforcement side of the FBI's house and the counterintelligence side of the FBI's house. Actually interposed this regulatory wall so that they had difficulty cooperating with each other for precisely the reason that the Justice Department was concerned about abuse if the FBI and the Justice Department were to use their counterintelligence powers as a pretext for conducting a criminal investigation. So it seems to me that if you flash forward 20 years, what was scandalous back in the 90s was the thought that you would actually use these counterintelligence powers as cover for conducting a criminal investigation. And now what we actually have is sort of an official blessing of using counterintelligence powers to conduct the criminal investigation under circumstances where the regulations that Special Counsel Mueller operates under actually say that you have to have a crime. They say that there must be a crime, there must be a factual recitation of what the crime is in the appointment of the special counsel. And the idea behind that, I believe, is that the articulation of the crime becomes the parameters of the investigation. It becomes a sort of a boundary or set of boundaries for the special counsel's jurisdiction, with the understanding that the special counsel then has to go back to the Deputy Attorney General to get additional authority if he wants to investigate things outside that ambit. But I'll close with this. I think that the politics of these situations so overwhelmed the law, and did so in this investigation, that one of the very first things that Deputy Attorney General Rosenstein did after appointing Special Counsel Mueller was to have a meeting on Capitol Hill with leaders in the Senate. And when they came out of the meeting, what I guess it was Senator Schumer, who was the minority leader, and some other senators said, was that they had gotten assurances from Rosenstein that Special Counsel Mueller would be able to chase the facts wherever he decided to chase them, and that there'd be no limitations on his investigation. He could follow the facts wherever he decided they went. So you had a situation where you're appointing a prosecutor with no crime, and then you're making a guarantee to the people who are going to exercise oversight over this that wherever the prosecutor decides the facts goes, the prosecutor can chase them. So we're really in a situation now which is, to my mind, antithetical to the American tradition. The American tradition is we have a crime, and then we assign the prosecutor to investigate the crime. And in this situation, it seems we appointed a prosecutor and told him to go on ahead and try to find a crime and have no limitations on that pursuit. And that's simply not the way it's supposed to work.
So in a moment, I'm going to open it up to questions from the audience. I would ask when you're acknowledged to just introduce yourself, say who you are, and then the proper way to ask the question is to say one or two sentences and end it with a question mark. If it goes beyond that, I will be cutting people off. Let me throw out two or three things, and you can respond to whichever of these you want. So Andy, you just made the point that politics often overwhelms the law in these sorts of situations. Is it possible for a regular U.S. Attorney's Office to conduct an investigation into the president or cabinet members, or is that out of the question? I'm throwing the other questions out there on the table, and you can pick which you want. And what are the role of Congress? I mean, if the whole point here is to, at least with respect to the president, prepare potential articles of impeachment or a report, Congress is waiting this whole time for this investigation to take place. It pulls its punches on oversight hearings. Congressional investigations certainly can screw up prosecutions. Saw that with John Poindexter and Oliver North. But is Congress right to sort of take a back step or wait in the back while the special counsel does his work? Or would it be better if they were more aggressive in terms of uncovering these facts for themselves and having oversight hearings? And I guess my last question, Ken, I'll direct towards you. I was struck in your book that you made the point that you consider that the president has an obligation, I assume it was an ethical obligation and not a legal obligation, to cooperate with this investigation against his activities. And I'm curious as to why you think that's so, particularly given the potential jeopardy that a president faces by doing so. And if you do think it's so, how far does that extend? So I'll throw all that out there and let you all pick and choose what you'd like to respond to.
Well, I spent 20 years in the U.S. Attorney's Office that likes to call itself the Sovereign District of New York. And I think if you took a poll, you'd probably get 100% return that we could investigate anything and with no limitations. And people would clearly believe that. Part of the thrill of working in a place like that is the ethos of the office was people actually did believe that there was nothing that there was nothing that we couldn't do in the sense of getting around any complications that might encumber an investigation. I think down here on planet Earth, the way things probably work is that everything is a matter of personnel more than is there a structure that can make this work. So I think if you had the right president and you had the right United States attorney, sure, a United States Attorney's Office could conduct the investigation with integrity. But the only way that you could carry that off, and this again I think is the injection of politics in it, is if the public bought it. Which is to say, does the public really believe that this prosecutor has the integrity, notwithstanding that he is a subordinate executive official, to investigate his superiors? And does the public really believe that this president has the integrity, or even the belief that I've done nothing wrong, to say, have at it, and when you come back, I'll be vindicated? I wouldn't want to sell that as a structure. I think you'd have to be very lucky to make that work. You'd have to have exactly the right people to make that work. As far as Congress is concerned, I really think Congress has become dependent not just on the Justice Department, but probably on many of the agencies and bureaucracies that it has created. One of the ways we see that, just to step out of this for a second, in Brett Kavanaugh's hearings over the last few weeks, this idea that, oh my God, we can't possibly go on unless we have an FBI investigation, unless we, give them another week to look at it. The staffs of the committees, and particularly the Judiciary Committee, are very good, and they're pretty robust, and they staff up when they have things like, Supreme Court nominations. And the people they go out and hire are people who used to do what I do for a living, or people who used to, be federal investigators, FBI agents, and the like. They're perfectly capable of doing their own investigations. That's not to say that the Bureau isn't value added. Of course it is. But I think in an impeachment situation, the idea that Congress would have to wait on and depend on the FBI to do an investigation that the Constitution really obliges the Congress to do itself, because it is the body that is supposed to be overseeing the peer branch. We'd be in a bad place, I think, if they had to rely on the FBI to do it. That's not to say they wouldn't, and there's certainly no small amount of waiting around to see what Mueller's going to do. The idea being that Congress, for whatever reason, can't do whatever it would do until they see what Mueller has done. I think that's a dependent relationship that's not good for the country, but there's no reason they can't do it themselves.
3 points in addition to your question, 3, but I'll be brief. Picking up on what Andy just said, we have people here in the audience who are deeply familiar with and experienced in congressional investigation. Keith, you may want to give a speech at the have a private session with those who are interested in this. And I align myself with what Andy has just said. The founding generation, again speaking through the Federalist Papers, call for energy in the executive. And there are times when I think many of us would say, let's see greater energy in the Congress. And I would cite an historical fact that supports that notion, as opposed to a culture of deference, allow the special counsel, the independent counsel to go forward. During the Senate Select hearings on Watergate, the breakthrough about the Oval Office tapes came through the Senate process, not through the special prosecutor's offices. The examination in the United States Senate, and there was a staff interview with Mr. Butterfield, who said, by the way, they're tapes, and the rest is all history. Without those tapes, history may have had a very different turn, because it was the tapes themselves that convinced thoughtful Republican members of the House Judiciary Committee that the President of the United States, for however long, did in fact enter into a conspiracy to obstruct justice. So there you have an example of energy. With respect to what Andy first said, that we can go get it here in the sovereign Southern District of New York, there have been lamentations, including coming out of this venerable institution, to the effect that we have wildly overcriminalized the law, and that we've intruded deeply into the province of the states in our federal republic. The Supreme Court will have before it, now that there are 9 justices, and I'm thankful for that, on the Supreme Court, will have an argument coming up with respect to the concept of dual sovereignty. I see nods saying that. I bet there's some people who've been involved in this policy issue, but it's ultimately a constitutional issue, which is same bank robbery, state of Alabama gets a criminal conviction, and the sentence is 1 year or whatever, and the federal government says, in effect, that's not enough. I think we're going to bring charges, and did, against the same woeful defendant, who probably regrets the fact that he chose that particular bank or didn't get a little bit of a longer sentence. But the dual sovereignty idea is, well, the United States looks at what the state did and says, we are not satisfied. The Civil Rights Division, of course, is empowered specifically to go after individuals who may have been convicted of some state crime. Dual sovereignty. I commend to you, by the way, a very intriguing brief which I just happened to run across by Senator Orrin Hatch, and it's an amicus brief in this case urging the court to take a second look at dual sovereignty. And I'm sorry, I'm talking in code. Double jeopardy. You can't charge the same person with the same crime, right? Double jeopardy law. You shall not be. This is a basic right under the Bill of Rights. But anyway, Orrin Hatch, the canopy under which he writes this brief is the overcriminalization of federal law. And there's been such a vast overcriminalization, as he sees it, federalizing of criminal law that should belong to the states, that the court should take a second look at the doctrine it created. There's nothing in the Constitution that says there shall be dual sovereignty. It's a natural conclusion emerging from our federal structure. It makes sense, right? You got a U.S. attorney, you got a district attorney. With respect to the duty of the president, you're so thoughtful in raising that question because I do take the provocative position that it was wrong ethically for President Bill Clinton to side with 3 fraud artists, Jim and Susan McDougal, and Jim Guy Tucker. But his law firm was actively involved in working against a federal prosecution. To me, that raises tensions with the idea of the faithful execution of the laws. I think the president just has to, as a matter of ethics and ultimate sort of ultra-constitutional responsibility, to say, I step aside, I can't have my lawyers protect me, but I can't have them standing in the way of a duly authorized federal prosecution.
Okay, so with that, let's stand this gentleman right here. Raise your hands. If you're behind one of the poles, stick your hand to the side so I can see you. But wait until we get a microphone to you.
Armin Choksi, given what has been said about the fact that the Mueller investigation started under an intelligence operation rather than a criminal one, and given that the regulations, as you claim by the DOJ, is that a criminal investigation is necessary or a criminal evidence of a crime is necessary, can there be a legitimate case made against, a legal case made against the Mueller investigation that it is illegitimate?
I think not. And one of the neat things about the regulations that we didn't cover, but we probably should stay up front, is that the very last of the regulation says, much like the first page of the U.S. Attorney's Manual says, that the fact that they've laid out regulations does not create rights that are enforceable for anyone against the Justice Department. So in a sense, the department can take, I think the department is obliged to follow the regulations, but they can take them as if they were basically suggestions, I think.
May I add, I think there's inherent authority in the senior officers of the Justice Department for the Attorney General to say this needs to be done in the public interest. By the way, in the book, I have a very detailed conversation about should we have gone in the Clinton case again for impeachment, or should we have had a more serious conversation about a lesser remedy such as the sanction, a resolution, or a sanction of censure. Some historical precedent, not deep, not rich, but of Andrew Jackson, who responded to a censure of the Congress by authoring a brilliant refutation of the power of the Congress to do anything but impeach. It's impeach or let alone. What I think the Clinton episode teaches us is there are certain kinds of criminal offenses. What is a high crime or misdemeanor? There's a lot of conversation about that. But clearly, perjury is a crime. Obstruction of justice is a crime. But I think the issue there was the nexus. Did those crimes that were proven, we believe beyond a reasonable doubt, were basically accepted, yes, he committed those crimes. Is there a sufficient nexus with the conduct of office of the president? So you have a criminal, go back to my hypothetical, the assault and battery against the hapless, cynical caddy. That doesn't seem to we really need to impeach the president for that? how about a resolution of censure? So there is this question of fit of custom. The final thing I'll say is I think that the department, though, this will be resolved under this court, not necessarily this term, but the department's interpretation of its own regulations are entitled to sort of uber deference. So if the Deputy Attorney General reads this, inherent authority on the one hand, and then this is just the way I interpret those, as not as expressio unius is exclusio, oh, I love that, alterius. Scalia is so proud. You've got to use some Latin every now and then, but to include one isn't to exclude the other. And so I think some combination of that would cause Rod Rosenstein to rest easily at night.
Just for the sake of completeness, I would just point out for your edification that I know there's going to be an argument upcoming in the D.C. Circuit Court of Appeals. So someone received a grand jury subpoena. I think his name is Andrew Miller. I could be wrong about that. From Mueller, he refused to comply with that grand jury subpoena. He turned over documents, but he refused to testify. He's been held in contempt, and that contempt has been held in abeyance while he appeals. And his argument essentially is that Bob Mueller, as an outside private lawyer, was not properly appointed in accordance with the Appointments Clause, and that Rod Rosenstein, who is not the Attorney General, could not appoint him, and that therefore this investigation is void ab initio because he wasn't properly. I'm not talking about the merits of that, but I know that argument is taking place. And I was, of course, curious, Ken, when you talk about censure as an alternative, that's of course after they declined to convict President Clinton, that's what they ended up settling on, and your successor, Robert Ray, I guess, settled for censure by a judge, and I guess it was Susan Weber, right?
Well, it was a finding, and thus the name of the book. The name of the book, Contempt, emerges out of the fact that President Clinton is the only president, thankfully, in American history to have been found held in contempt of court. And he did not appeal that judgment of contempt for the way he conducted himself in the civil case.
Next question. Back here.
Mike Iroshis. Will we ever see the mandate that Bob Mueller is actually working under? And Mr. Starr, was your mandate ever revealed to the public?
I can answer yes. Mine was, and the expansions were made publicly available. Andy, do you want to speak to the Mueller mandate?
I think, I hope eventually we'll see it. I know Congress is pushing to see it. I think we should already have seen it. The state of play is, and I guess I should fill out the facts. After Rosenstein appointed Mueller it was on May 17th of 2017, there was a lot of noise raised. I made some of it myself, but there's a lot of other people making the same kinds of sounds, that the appointment was not supported by an underlying crime. And I think between that line of criticism and the fact that they were about to bring charges, or at least were clearly contemplating charges against at least Paul Manafort, and were, I think, wisely anticipating that some of these claims would be made, the Deputy Attorney General then fleshed out Mueller's jurisdiction in a memo of August the 2nd. And the only parts of the memo we've been allowed to see, I think if I'm remembering right, it's fairly short. It's about a 2.5 page memo at the most. But the only parts we've been able to see are the two passages that deal with Manafort. So I would estimate about 4/5 of it has still been withheld. I don't understand why. My understanding is they say they're concerned about is they don't want to prejudice uncharged people, and they don't want to compromise the government's investigation. I think you could handle the prejudice uncharged people by simply redacting the names out. And as far as prejudicing the government's investigation, at this point it seems to me that in most investigations, secrecy is very important and should be a priority. In an investigation where the president has been operating under a cloud for 2 years, I think that should take a backseat to trying to clarify what the status of the presidency is. But in any event, my view, for what it's worth, and that maybe this will all be shown someday, and I'll be totally wrong about this, but I think they relied on the Steele dossier in fleshing out the jurisdiction of the special counsel. There's certainly indications of that in what we've seen about it from Manafort, because one of the passages on Manafort that we're allowed to see says the allegations that Manafort colluded with Russia in the interference in the 2016 election. I don't know of any other evidence. Now, there could be some. You always have to qualify that the government knows a lot more than we do about its investigation. But I know of no other evidence connecting Manafort to Russian cyber espionage in connection with the investigation, the election rather, other than what's in the Steele dossier. And I suspect that the Steele dossier was used, whatever other people are named in that memorandum, I'm intuiting that the dossier was used, and that would be a fairly explosive fact if they had to reveal it.
The questions? Down here.
Thank you. Leon Peace. My question is, with respect to the what used to be the dual prosecution policy at the Department of Justice, under these circumstances, would the political factors also be considered, either formally or informally, as in the application of that dual prosecution policy?
Dual sovereignty?
Go ahead. Are you talking about the dual sovereignty question? Oh, yeah, I'm sorry. The microphone's coming back. I apologize.
Sorry. Yeah, there used to be a policy called the dual prosecution policy, whereas there wouldn't be any additional prosecution.
Yeah, I think I understand what you mean. I did a number of these cases because in the sovereign district anything is possible, and including eviscerating double jeopardy if that's what's necessary to do justice.
Why are we laughing?
I really did mean that as a joke, by the way. But you're quite right. There was a policy that stated that the presumption is that once a prosecutor has his shot at you, that's it, and that the Justice Department doesn't hop in every single time there's a dual sovereignty situation. Now, let me tell you the kinds of dual sovereignty cases I had. The one I think that was closest to the line was I had an undercover police officer who was shot in the back during a drug buy. Could not identify the shooter, who he never saw. It was a hooded person and who shot him in the back. The jury acquitted in the Bronx, shockingly, and the DEA and the NYPD came to us and asked us to consider bringing that case again. And there were other charges. It wasn't a straight up double jeopardy question because they were involved in a narcotics organization, so there was a way to charge it so that it wasn't black and white double jeopardy. But we did have to go through the internal Justice Department process, and on that occasion they found that it was a serious enough misconduct, and they had other circumstances where they allowed us to do it, but it was not a slam dunk. And there's a lot of back and forth about whether we should be allowed to do it. And by the way, even when you're allowed to do it, in terms of a jury trial, juries don't like dual sovereignty cases, at least in my experience. They don't like the idea that the feds kind of sit back and wait to see what happens, and then somebody has a full shot at a trial in a state court, and then the feds come in and put you through a second trial. My experience, at least, is that juries have a lot of trouble with that.
Oh, well, I was going to say, with respect to, because the underlying issue that you identified in your thoughtful question was, do political considerations enter into this? And Andy's been on the front line. I would say that history is teaching us that politics is always driving the issue of the appointment of the special prosecutor, always. Indeed, that was true in Whitewater. Whitewater came to be as an investigation because the President of the United States, during international travel, made the political judgment that a special counsel, we would now call that person, should be appointed. So Bob Fisk, very able former United States Attorney for the Sovereign District of New York, a partner of Davis Polk in New York, wonderful law firm, great lawyer, was appointed in January of 1994 by Janet Reno on the direction of the President of the United States. It was not her assessment under any regulations or otherwise. Now, again, this was during an interregnum or an interim period when the independent counsel law was not in effect. When you look back in time at the different appointments of special prosecutors, it's always driven by politics and a sense that we need honest government, there may have been wrongdoing, and so forth. Here is the key challenge for the special counsel and the independent counsel. How do you free the investigation completely from politics, neither fear nor favor, and what are the guardrails that you can build in that provide public assurance that the administration of criminal justice is free of politics? It's especially difficult to accomplish that no matter what kinds of internal safeguards you have. And our own investigation, as I say, we had a very elaborate indictment review process that not only mirrored and echoed what the public integrity section of the criminal division of the Justice Department does, and wisely so. It's not just the discretion of, well, here's the investigation team. They've been given the authority to go forward if the evidence so. No, we're going to review that in Washington, D.C. if you're going after Congressperson X in California. It's not up to the Central District of California, et cetera. So there are these built-in guardrails, but I think where the independent counsel law utterly failed is even when we would bring in these guardrails, such as super indictment review. And one of the reasons that, as I describe in the book, we did not go forward with an indictment against Hillary Rodham Clinton, even though we were persuaded she had committed crimes in Arkansas. Well, that's a pretty significant thing to conclude. But this has not been made known until last month. I don't think the American people knew that. Well, why didn't you indict or seek an indictment at the Little Rock grand jury before it expired in May of 1998? Because we went through a very elaborate indictment review process, and participating in that, here's one of my guardrails. Sam Dash, the Democrat counsel to the Senate Select Committee. But it's very hard for that to get out at all and to provide any kind of assurance that this is not, quote, a rogue prosecution that's politically inspired.
So I'm not predicting this will happen, but I'll tell you where I think the dual sovereign doctrine could be involved in terms of this investigation, which is that there's been speculation or fear in some quarters that the president might choose to pardon Paul Manafort and Michael Cohen. And of course, his pardon authority is limited to federal crimes. So New York authorities, I know, immediately said, oh, well, we're going to investigate them too. And of course, if they ended up charging them and convicting them of crimes, that would be something the president could not pardon them for. But I'm not saying that's going to happen, but that would very much implicate the dual sovereign
very
doctrine.
much.
So let me ask one of the questions. You talked about how politics are inevitable in terms of this, and we're coming up to a midterm election, and you know the independent counsel, special counsel, his investigation continues apace. Some prosecutors have chosen to say, all right, we're going to have a buffer period and not do anything. Others, the one that comes immediately to mind was Lawrence Walsh and Iran-Contra, indicting Casper Weinberger on the eve of the Clinton-Bush election. How does this play, and should this play, in terms of how Bob Mueller proceeds for at least the next little while?
I'm happy to take the first crack because, as has been revealed during the Brett Kavanaugh hearings, but happily this was eclipsed, not happily, but the issues surrounding his distinguished service in the independent counsel's office got eclipsed by other questions. I mean, during the main confirmation process. But I was insistent that we get the referral out as promptly as possible after the president's testimony of August 1994. And we did get it out right after Labor Day, September 9, 1994. And the very reason was we had the midterm elections coming up. So Justice Department policy is, in fact, to be mindful of the democratic process and to time, if at all possible, the exigencies of the honest administration of justice may eclipse this, but you try your best not to interfere with the democratic process.
That certainly is true. I've always had difficulty with this. I mean, it's clearly Justice Department policy, so it doesn't matter if an individual prosecutor has a problem with it. But it has always just seemed to me that not doing something that should be done and that is ripe to be done is equally as bad as doing something rash in the period of time in the run-up to the election that can have an effect on the election. So I've never been crazy about that policy, but even people who think like I do don't think that you should drop an indictment like 2 days before the election. So, you know, it's obviously the rule of reason applies. I don't think, it seems to me from the course of Special Counsel Mueller's investigation that it's winding down and that we've probably seen the charges we're going to see. I don't think he ever would have given his report to Deputy Attorney General Rosenstein under circumstances where people would be demanding it in that period right before the election. I think he would wait until after the election for that. But from what we've been able to see, you know, he's brought a couple of indictments against groups of Russians that seem to cut against the idea that there was a conspiracy with people on the American side. The cases against Manafort, which are unrelated to the real mandate of Mueller's investigation, have wound down now and been closed out. There doesn't seem to be anything else on the horizon. What we see is the cases that he has brought are being transferred to other components of the Justice Department. One of the Russian cases went to the National Security Division. Another one went either to the Eastern District of Virginia or the District of Columbia. I don't remember which. And the other thing we see is that there are some reports that a number of people on his staff have started to go back to the jobs from which they came in the first place. So it's got to, at least objectively looking at it, to me, it seems to have a sense of winding down. It doesn't look to me like the kind of gearing up that you would see, I think, if you were going to see big charges.
Well, Andy is following this very closely, and as the one contributor to a closely watched network, I defer entirely to him. I do think this. I think that the public has underappreciated the power of those indictments. Now, they're indictments, they're charges, but they are speaking indictments. They are very detailed, and when one reads those indictments, the inference one naturally draws is no collusion. Doesn't say there was no conclusion, you wouldn't expect that, but the natural, most reasonable inference to be drawn from the two indictments, at least from this reader, and I read them carefully, is zero collusion. To the contrary, they duped some people, right? And just the series of crimes that were committed just cry out for condemnation of what the Russians did. According to the indictment, I know, presumption of innocence, even if you're a Russian individual who comes here under these false pretenses and so forth, commits crimes to get in the country, commits crimes in the country and so forth. But I think he has done a great service to the public by doing the work. Andy will understand it far better than I will, doing the necessary work to say this is what happened during the presidential campaign. One of my favorite examples is when these Russian thugs were funding both a pro-Trump rally and an anti-Trump rally in New York on the same day. I don't call that taking sides. Is that sort of hedging your bets or something?
Well, to those of you who are here, we have copies of Judge Starr's book outside for sale. I'm sure he'd be delighted to stick around and sign one for you. And I'm afraid we've run out of time, so please join me in thanking our panelists.